Hello everyone, this is Cao Zhaoxun and Ramalinkan from Faculty of Law, University Kebasan, Malaysia. Our research paper topic is study of children's testimony in the China's legal system. The child witness system is an important part of the evidence system. However, judging from current status of China's legislation and judicial interpretations, there are few provisions on the qualifications of child witness, rules for child witness to testify, child witness protection, and other related issues, resulting in a lack of compliance in practice. At the time, in judicial practice, the relevant staff do not attach importance to the rule of children's testimony. This is not powerful to giving full play to the rule of child witness in the proof of proceedings, nor is it powerful to the effective protection of the legitimate rights and interest of child witness. Based on this article attempts to explore the improvement of China's relevant legal system in terms of the key aspects of the child witness system using a qualitative research method and taking into account the useful experiences of countries with different legal systems. This study found that children's testimony is characterized by the psychological and physical honorability of witness, the subjective nature of the testimony, and the fact that the testimony is easily mispretended but true. In China, although there are no restrictions on the qualification of child witness, this extent of overly broad rules often results in children being disqualified as witness. This study makes a number of recommendations in this regard. In terms of legislation, lower the standards for child witness qualifications to allow child witness to be better participate in the proceedings, strengthen the accreditation process for child witness by distinguish them from ordinary witness and introducing separate legislation to this effect. Secondly, strengthen access to evidence and supervise judicial officers who investigate and take evidence to ensure the ability of children to testify during investigations and depositions. Finally, introduce third-party agencies to assist this taking of evidence, such as psychological counseling agencies, and use the powerful social agencies to protect the testimony process of child witness. The body of this paper consists of 4 main sections. The first part is a definition of children testimony. It includes the concept of children, the concept of testimony, and the characteristics of children's testimony. The second part focuses on the qualification of the child witness and examines the rules governing the qualification of child witness in China, namely whether the child is capable of understanding the question put to him or her by the interviewer, and whether he or she has the ability to express himself or herself in words. The third part of the study focuses on the rules governing the testimony of child witness, including the collection of child's testimony, the appearance of child witness in court, and the examination of child testimony. The first part focuses on the protection of child witness, examines the shortcomings of China's current legislation on the protection of child witness, and incorporates the relevant measures from abroad to build a system of child witness protection measures in China. Article 1 of the UN Convention of the Right of the Child states that the age of the child to whom the truly applies the 18 years, unless otherwise specified by states. In civil law jurisdictions such as France, minors under the age of 16 are considered to be children. In addition, Section 60 of the German Code of the Criminal Procedure provides that an oath is not required if the person is under 16 years of age at the time of questioning. In Taiwan, China, the Code of Criminal Procedure provides that witnesses may not give evidence before they reach the age of 16. In common law jurisdictions such as the United Kingdom, a child in criminal proceedings means a minor under the age of 14, and a child under the age of 14 cannot give sworn testimony. In American criminal proceedings, a child in a minor under the age of 14, excluding the two groups of infants who are unable to speak and express themselves clearly and minors who are fully developed in all respects. The age range of children in China is between the ages of 3 and 14. In China, in a broad sense, anyone who has direct or indirect knowledge of what happened in a case or who has only partial knowledge of the details of the case is able to be called a witness. It can be therefore seen that there is some variation in the status of the provider of the testimony in the proceedings. Definition of the children's testimony. Characteristics of children's testimony. There are about 4 characteristics about the children's testimony. First is vulnerable. In case involving children, as their growth and development is closely linked to their own age, young children are physically and psychologically more vulnerable as key witnesses and are susceptible to secondary victimization during the factual examination. Subjective. Children's perceptions of the details and values of a case being ambiguous and strongly subjective. Error-prone. Children's lack of memory and comprehension can lead to discrepancies between testimony and facts. Authenticity. Although children's lack of cognitive ability can have an impact on the value of testimony, they are generally more likely than adults to give truthful testimony without outside interference and are less likely to deliberately lie. The qualification of child witness. In common law system, the qualification of a child as a witness in England depends on the child's ability to understand the matter, the child's ability to understand the questions, and the child's ability to give answers that are understandable, which are criteria for judging child witness in England. It is for the judge and the jury to decide whether the child's testimony is true or false in the course of the trial. This facilitates the speedy ascertainment of the truth in the case, allowing contradiction and doubts in the testimony to reasonably excluded and saving legislation resources. In the United States, no explicit restrictions are placed on child witnesses, who are only required to be able to perceive, remember, and express the facts of the case and the obligation to tell the truth in order to qualify as a witness and testify in court. There are no strict restrictions on age, mental state, etc., and this is recognized in the U.S. jurisprudence and statutory law. As for the qualification of child witness in civil law system, in German criminal procedure law, the condition for being witness is any person who has the capacity to perceive and is able to express himself. It is important to know that the reliability of a witness testimony should not be confused with the qualification of a witness. The identity of a child may affect the reliability of a witness testimony, but not his or her qualifications as a witness. In civil proceedings, in principle, anyone can be a witness, and the ability to perceive, memory, reliability, age, mental state, relationship to the facts of the case, or to the parties are not elements of qualification, but are factors to be taken into account when examining the testimony of a witness. In French civil procedure law, a person may be heard under the same conditions even if he or she is not competent to testify, but is exempt from the obligation to take an oath. There are no legal restrictions on whether a child can be a witness. As for the qualifications of child witness in socialist legal system, in China's criminal proceedings, the ability to distinguish between right and wrong and to express oneself correctly is a criterion for a child to be qualified as a witness. From the Chinese law, there are no too many restrictions on the qualification of children to testify, but no closer inspection. There are provisions that are too broad and principled, which in practice tend to cause judicial inconsistency. Chinese law provides that a person who is too young to distinguish right from wrong or experiences himself correctly cannot be a witness. However, the law does not clearly define what constitutes a young person, how to determine whether he or she knows right from wrong, and to what extent he or she knows right from wrong and expresses himself or herself correctly. This means that in legal practice, the eligibility of a child to testify is left to the decision of the prosecution and defense, who may interpret the restrictive conditions set by the law and in their own way, which may result in the child not being able to testify. So let's talk about the taking and the admissibility of children's testimony. Basic principles of the Convention on the Rights of the Child. First is respect. In its first part, the Convention makes it clear that the child's right to live in indigeneity is one of the key principles to which it is based. First is non-discrimination. Article 2 of the Convention sets out the principle that states parties should protect children from discrimination and punishment on a basis of inter alia, their identity and beliefs. Third is best interest. Article 3 of the Convention provides that the best interests of child victims and witnesses are to be safeguarded in the administration of justice. Final is the respect for the views of child witnesses. Article 12 of the Convention provides of respect for the views of child witnesses in the administration of justice and ensures that all child witnesses are free to express their views. What's more, the principles for the taking testimony of children in socialist legal system, such as Article 87 and 90 of the latest Supreme People's Court judicial interpretations on the application of the criminal procedure law of the People's Republic of China, and the guidelines of criminal prosecution of minors for trial implementation issued by the Supreme People's Procuratorate refine the specific standards and operation procedures for handling cases involving minors, and the People's Procedures Minors Proceeding Department innovates an integrated working model in which the same case officer is responsible for the handling of a criminal case, ensuring the timelines and the effectiveness of the evidence collection and avoiding the exclusion of inconsistencies in some testimonies due to multiple questioning and loss. The evidence will be excluded due to inconsistencies in the sum of the testimonies as a result of multiple questions and loss of validity. What's more, in 2015, the Supreme People's Procedures issued the 8 measures for strengthening judicial protection of minors by procedural organs. It also talks about the principles for taking the testimony of children in socialist legal system. So let's talk about the problems of the children's testimony systems in China. There are currently many problems with child witness testimony in China. From the legislative point of view, there are almost no relevant provisions on child witness testimony, and there is a lack of a comprehensive set of legislation provisions. The legislation is lacking in terms of provisions on both the qualifications of child witness, the procedures for collection child testimony, the examination and judgment of the credibility of children's testimony, as well as the manner in which children testify in court, and the protection of child witness, most of which are mixed up with the provisions for adult witness. In judicial practice, due to the lack of in-depth research on child witness, there is a lack of proper understanding of child witness on the part of judicial staff, the lack of timely collection of child witness testimonies, the lack of professionals who understand the psychology of children, the lack of relevant hardware and the equipment required of child witness to testify, and the neglect of the protection and the recovery of the psychological health of child witness, etc. So we have 2 reflections on the improvement of the guarantee of the children's testimony system in China. First, we should establish the qualification of child witness. Second, improving the process of collecting child witness testimony. Third, we should improve the review and determination process of children's testimonies. First, we have to improve the way child witnesses testify. So, the 2 main characteristics of child witness are the fiability of their testimony and the psychological honorability. So, they must be given special care in criminal proceedings in order to achieve the effect of other adult witness testimony. This is not only determinable to the discovery of the truth in a case, but also the protection of child witness. The law should make detailed provisions on the examination of the qualifications of child witness, the collection of child witness testimony, the examination and judgment of child witness testimony, the manner of the child witness testimony, and the special protection of child witness, so that the law can be followed in practice. That's all I want to talk about. Thanks for your listening. This is Cao Zhaoxun from Faculty of Law, University Kabasan, Malaysia.